अगर डिस्चार्ज हुआ है तो उसका मतलब है किसी ने बड़ा चढ़ा के केस बनाया था। पार्ट डिस्चार्ज भी जब होता है तो इसका मतलब है फर्स्ट इन्फॉर्मेशन बड़ा चढ़ा के झूठ डाल के बनाया था। स्टेटमेंट्स बड़ा चढ़ा के झूठ डाल के बनाए थे। जो फर्स्ट इन्फॉर्मेंट है या था या प्रोसिक्यूशन विटनेसेस थे, उनके ऊपर मैंने केस नहीं डाले तो इसका मतलब ये नहीं है कि मैं गुनहगार हूँ, पर्टिकुलरली व्हेन रिलेटिव्स आर देयर इन द केस। I have deposed, I have forgiven them, and that is why I did not file a case, which means the case has to be objectively decided whether it actually happened. Something had happened, but what had happened is to be assessed in the trial. If everything told to the police had to be truthful, there would be no need of trial. If everything had to be as told to the police, then why are courts necessary? Why are lawyers required to defend? Everybody had to be convicted, which means the entire system believes that whatever is told to the police may be wrong, may be exaggerated, may be out of command, may be by the aggressor himself, and may be many other reasons. ये कोई भी जान सकता है. Even the Supreme Court has said many times, cases are of three types. Cases which are brought by the police or in the courts are of three types: wholly reliable, wholly unreliable, and partly reliable, exaggerated. Which means the evidence of each and every prosecution witness could be entirely false, could be entirely truthful, or could be partly truthful and partly exaggerated or falsely stated. The entire process in the trial is to know exactly what it is, whether each prosecution witness towards each of the charges is wholly truthful, wholly untruthful, or partly truthful. That is what evidence evaluation means. How does one know? How does a person know? How does a judge know? How does a lawyer know whether somebody has spoken partly truthfully, wholly truthfully, or wholly untruthfully? How does a person know? How does any lawyer or judge know? How to know? That is what evaluation of evidence means. There are some principles, there are some fundamentals for evaluation of evidence. First, the charge is like the goalpost. Anything outside the goalpost does not have to be defended. If the charge is that you had slapped somebody, एक थप्पड़ मारा था तुमने, suppose, and if it was a false allegation, suppose if the deposition is that थप्पड़ नहीं मारा था, लात मारा था पाँव पे, even if there is no cross examination, acquittal, because the first fundamental is that any deposition which doesn't have what is stated in the charge, it means that the charge is not proved. The charge was not for a lath, it was for a thappad on the face. And lath on the leg, deposed by any witness, does not prove the charge. Therefore, acquittal. This is the first fundamental for acquittal. If what is stated in the charge is not deposed at all, there is no other decision on the charge possible. And such evaluation has to be done in relation to each of the charges, not clubbed together. Because decisions are to be made towards each of the charges, not clubbed together. Why? Because each charge has a distinct composition as to what an offense, what a crime, what a wrong is, punishable wrong. Clubbed discussion makes everything vague. It is not allowed by law. Therefore, towards each of the charges, the depositions are to be scrutinized. The first fundamental I said is, if there is no deposition at all towards what is stated in the charge, that means the person deserves acquittal, even if there is no cross-examination and there is no defense evidence. This is the first fundamental. Because it is like a shot outside the goal post. It is not a goal. Second fundamental. If somebody had stated to the police that there was a slap given on him, And in the court, if he says there were 5 slaps given, to the police he had stated only 1 slap was given. In the court, he states that there were 5 slaps given. It means he is a definite falsity speaker. He is exaggerating because of enmity. It is an afterthought. He is creating his own. He is creating his own afterthoughts, falsity to trouble. 1 mark and 5 marks are not the same, even in exams. So 1 slap and 5 slaps are not the same. It cannot be used to send somebody in the jail. He is definitely speaking falsity. किसी को 1,000 रुपया दिया बोलता है, बाद में 1,000 नहीं 5,000 दिया बोलता है. It means he is talking falsity intentionally to send the person by using falsity to send the accused to the jail. He is intentionally creating exaggerations. He is speaking falsely. This is a contradiction, and such contradiction means that the person is talking falsity. Contradiction means contrary to diction, contrary to deposition, opposite to what is deposed. This law is explained in Tehsildar versus State of Uttar Pradesh, AIR 1959, Supreme Court 1012. Constitution Bench decision, 5-judge bench unanimous decision, AIR 1959, Supreme Court 1012. 2 fundamentals over. Third fundamental. If somebody says that he was given a blow with key on his face, to the police he had not even stated this. If it had happened, he would have stated to the police, right? Whatever he has deposed in the court, therefore, is a falsity. It is so important that if it had happened, he would have stated to the police. Otherwise, why was the police statement taken? This significant omission, when it is present, it means it is equivalent to a contradiction and the person is talking falsely, the prosecution witness. This is the third fundamental. Fourth fundamental. If somebody says that a person was attacked gross inconsistency, both are saying both were present together, and one person is saying, the other person is saying, they are talking intentional falsity. This is called inconsistency, gross inconsistency between witnesses, and therefore they are talking falsely, and that means the person deserves to be acquitted. This is the fourth principle. Fifth principle, fifth fundamental. कोई अगर बोलता है that it happened in the public place and no public member, no impartial witness says that the crime was committed. If it had happened during broad daylight in a public place, and yet if no impartial witness says that the crime was committed, and particularly when they depose that there were many people, it is impossible that no impartial witness is available to say that the crime has been committed. This is the fifth fundamental. The sixth fundamental. If some prosecution witness deposes an improbability, example, the speed was such that the person was running but faster than the fastest of the motorcycle, it means he is talking falsely. It cannot be relied upon. The next fundamental. If there is disproof and in the cross-examination of the defense witness, nothing has been shaken, nothing has been shown to be unreliable, it is disproof of the prosecution case, acquittal. These are the most fundamental principles as to where any accused has to be acquitted. There are some other fundamentals, such as suppression of an important fact by the prosecution witnesses, creation of falsities by the police officials. There are some other fundamentals which entitle the accused to get acquitted. Yet, what I have stated now are the most fundamental among the principles where acquittal is the only option.